Hi, and welcome to this latest immigration law update video. In this video, I want to look at the test in the private life immigration rules of very significant obstacles to integration. Previously, that was in 276 ADE and is now contained within Appendix Private Life. And what I want to do is look at a recent decision of the Court of Appeal in a case called NC. That's 2023 EWCA Civ 1379, and is a decision from the 22nd of November 2023. Judgment was given in the Court of Appeal by Lady Justice Whipple, and she upholds the decision of Upper Tribunal Judge Smith. So the background to this case, look on your screens, paragraph 4 and following. The appellant was a national of St. Kitts and Nevis, born on 4th April 1987, came in 2016 when she was aged 28, and brought two of her children with her. The appellant claimed asylum, and her asylum and Article 8 claim was refused by the Secretary of State. The first-tier tribunal found that the appellant genuinely believed that there was a subjective threat against her in terms of 3 shooting incidents and the abduction attempt of her son. There was a son left in St. Kitts and St. Nevis. But they found that the appellant was not at risk in terms of the protection claim. However, look at paragraph 9 of the judgment. The first-tier tribunal went on to find, as a result of her subjective fear for herself and her children in St. Kitts, while I have not found the appellant has met the evidential burden to show that there's any real connection to CH, I found that the appellant subjectively believes she's in danger. I accept that subjectively she believes that the authorities are not willing to protect her. I think it is likely on the balance of probabilities that that would have a significant impact on the appellant's ability to conduct a normal life in St. Kitts and Nevis. I do agree, therefore, that the appellant would likely, on the balance of probabilities, to be unable to integrate into life into St. Kitts. She therefore meets the immigration rules, and the judge allowed the appeal on the basis that the private life rule, the very significant obstacles to integration rule contained at that time in 276 ADE 1 Roman 6 was met, and the appeal succeeded. Secretary of State appealed to the Upper Tribunal, and look at paragraph 11. The Upper Tribunal found that the judge had fallen in error by failing to take into account relevant considerations, such as whether her fear was objectively well-founded and whether there were other integrative links in St. Kitts, and that the judge had not asked herself the right question, objectively, whether there are very significant obstacles to reintegration, and not provided adequate reasons. The Upper Tribunal therefore set aside the decision of the first-tier tribunal and then had a resumed hearing at which they dismissed it. Permission was granted to appeal to the Court of Appeal, and the challenge was that the Upper Tribunal should not have found an error of law and that the first-tier tribunal decision was sustainable. Look at paragraph 16, because that's helpful. It says this: on issues of law, there was much common ground between the parties. Both parties accepted that paragraph 276 ADE 16 required the court or tribunal to reach a broad evaluative assessment of whether the appellant, if returned, would face very significant obstacles to reintegration. Both parties accepted that subjective fears to do with the appellant's own perception of risk and fear of harm could form at least part of that assessment, and that the appellant's genuine fear of reprisal was relevant. Both parties accepted that objective evidence, by which they meant evidence of factors which were not subjective, such as evidence relating to the availability of state protection and the social and family connections of the appellant, were also relevant. The Court of Appeal set out the correct legal approach by looking at some of the previous case law. I'm sure you're familiar with it, but it's worth bearing in mind, especially if you're preparing an application or appeal, arguing very significant obstacles. That's the case of Camara and what was said by Lord Justice Sales, as he then was back in 2016. The guidance given by Lord Justice Underhill in 2018 in the Parveen case, look at paragraph 23. There's also reference in this decision to a insurmountable obstacles EX1 case. That's the case of Lal. I always find Lal very helpful when I'm arguing insurmountable obstacles to the tribunal. But I want to focus on in this video is paragraphs 25 and 26, because this will guide your preparation of a case arguing very significant obstacles to integration. It says this: it is not in doubt based on those authorities that one, the decision maker or the tribunal on appeal must reach a broad evaluative judgment on the paragraph 276 ADE16 question. That judgment must focus on the obstacles to integration and their significance to the appellant. The test is not subjective in the sense of being limited to the appellant's own perception of the obstacles to integration, but extends to all aspects of the appellant's likely situation on return, including objective evidence, and requires consideration of any reasonable step that could be taken to avoid or mitigate the obstacles. So the assessment's a broad evaluative judgment, and we've got to look at all aspects of an appellant's likely situation, including objective evidence and reasonable steps that could be taken to mitigate the obstacles. So in preparing an application or an appeal, think about, have you submitted evidence to show what the condition, what the circumstances would be on return? That could involve country evidence. It could involve expert evidence. There's evidence about family situation, all those things. Maybe there's medical evidence that supports that. And then in drafting witness statements, have you addressed the reasonable steps that could be taken to avoid or mitigate the obstacles? Or have you tried to show that the appellant couldn't really take anything and those obstacles couldn't be mitigated, so they still are very significant? Paragraph 26, I would add this: the test posed by paragraph 276 ADE16 is a practical one. Regard must be had to the likely consequences of the obstacles to reintegration which are identified. So make sure you identify and set out those obstacles very clearly. In a case like this, where the only obstacle identified is the appellant's genuine but unfounded fear, particular care must be taken to assess the ways in which and the extent to which the subjective fear will or might impede reintegration. So how does that subjective fear that's not well-founded objectively, how would that affect somebody in terms of their reintegration if they've got this genuinely held subjective fear? And psychological or psychiatric evidence may help in relation to that. It cannot simply assume that it will. The likely reality for the appellant on resuming her life in her home country must be considered, given her subjective fear, and the availability of support and any other mitigation must be weighed. It is against that background that the judgment on whether the obstacles to reintegration will be very significant must be reached. So these two paragraphs need to guide your preparation and should guide the assessment then conducted by the decision maker and then the tribunal in any appeal. The Court of Appeal go on to look at the case itself and find that the upper tribunal was correct to find the first tier had made errors of law, and they were correct to set the decision aside. Therefore, the appeal failed and it was dismissed by the Court of Appeal. But I hope that's helpful to you in giving you guidance on effectively preparing and arguing cases based on private life in terms of very significant obstacles to integration. Thanks very much.